Thank you for joining us today for our webinar entitled Introduction to EU General Data Protection Regulation, Planning, Implementation, and Compliance. My name is Allison Schaefer, and I will be your moderator today. This webinar is the second of 4 of our Financial Poise webinar series, Cybersecurity and Data Protection. The slides provide a summary of the series as well as summarize this episode. Speaking of the slides, you should understand from the get-go that we will not be stepping through the PowerPoint in order, nor will you have to listen to us read any slides. This webinar, like all Financial Poise webinars, is a conversation. Keep the PowerPoint handy, however, because I will hop around throughout the webinar so you can take notes. Our wonderful and very knowledgeable panelists today are Alex Sharp, practitioner at Sharp Management Consulting, and Matthias Schorer, associate at Linklaters. As I said, my name is Allison Schaefer, and I'm legal and regulatory counsel at the Jump Trading Group. We appreciate that you're not spending your time and money to attend this webinar to hear infomercials about us. You can find more information about us at the end of the PowerPoint. This webinar is a production of Financial Poise. To sign up for the great free weekly newsletter, go to financialpoise.com/subscribe. If you're attending live today, you can submit questions using the web portal. And if you're watching this on demand or have any questions after the webinar, you can send us an email to info@financialpoise.com. Just include your question and the name of the webinar episode, and we will do our best to get you an answer. All right, let's get started. So first, we need to set the stage a little bit and learn about the basics of the General Data Protection Regulation, GDPR. So what is GDPR and what led to its passage? Alex?
Sure. Thank you, Allison. So GDPR, in a nutshell, is really the European Union, which is basically the European states. And I say basically because just because you're in Europe doesn't mean you're in the European Union. And, you know, you even have the UK that exited, but still honors with, the EU regulations. So it's a little involved, but I think it's officially 27 countries right now. And they created this uniform privacy framework that really dealt with the EU as one entity, right? So it was really very foundational that way. And it really set out the basic tenets of privacy. Now, one of the very unique things about GDPR is that 13 years before, they actually set out another privacy law that was 95. GDPR was 2018, and they really updated it. And one of the things that gets lost a lot around privacy, particularly foundational for GDPR, is that the GDPR was really established to form digital trust and protect consumers to foster business, right? Because the idea was one protects the other. But this is actually something that got lost with HIPAA, which everybody in the US has heard about one way or another. But the P in HIPAA is actually portability. It's not privacy. The original thought was by allowing consumers to transfer their data and be comfortable about transferring data, different insurance providers and the like, the market forces would drive down the cost. And at the same time, they could choose providers like doctors. It would increase the outcome. So the idea was by information sharing and openness and done in a way that protects the consumer so they could be comfortable with all this, that it would really drive down cost and improve the outcomes, which is the exact same thing we see from GDPR. And by having it across 27 different countries, we actually treat the European Union as one body instead of 27 disparate pieces trying to figure out ways to cooperate.
Certainly.
That's it in a nutshell.
In a nutshell, yes. I was about to say it has certainly evolved quite a bit still since 2018 when it was implemented, and how it's kind of spread since its passage. But thank you, Alex. And can you just define a few key terms for us the major players for GDPR. So what is personal information?
Well, personal information is just that. So if you look at GDPR, there's some things that GDPR does really, really well. And one of the things they do is they actually talk about natural persons, right? So they're separating a human individual from like computer software, and it creates this term called the data subject. So that is any individual person, a human, that can be identified directly or indirectly through specific types of information. And all of this is pretty obvious. And you could go through the law and look at the actual pieces, but it really comes down to the obvious things: name, identification number, like a social security or driver's license, location data, your DNA, genetic information, mental condition, economic situation, cultural or social identity, all the things that we see today as we use as ways of identifying ourselves. So when you look at the list, the nice thing is it's very well defined. It's right there in the articles, and there's lots of clarification and practice. To Allison's point, when it was put out in 2018, even though there was some nice lists, it still needed to be evolved and refined and understood. And now, effectively 6 years into it, we have a pretty good handle on it. It's become common knowledge, and that same list is found throughout the world. So it's not like we're doing something unique for GDPR. It really is, it really did set the stage for what we see across, globally.
Certainly. And I mean, it goes even as far, IP address, location data, which we're seeing so much frequently, with technology, which was one of the main catalysts for GDPR as well, at least the updated version. And as you said, data subjects, it must be linked back to an individual, which I think is a really key point that you made, especially with AI becoming so popular now and just seeing a lot in that space. Must be linked back to that natural person. So we hear a lot too about data processors, data controllers, and sometimes, it can get quite confusing. So, Matthias, can you kind of walk us through kind of what a data processor is, what a data controller is, and, how they compare to one another?
Sure. So, we've heard essentially that GDPR relates to processing of personal data, but I guess the next question is by who? And the answer is by controllers and processors. So a controller is someone who decides why the processing is going to take place and how the processing will take place. Whereas a processor simply actions the processing on behalf of the controller. They don't exercise any of their own sort of independent thought in relation to that. So an example would be, if a company is processing their employees' personal data in order to pay those employees, they're likely to be the controller. But their payroll service provider, if they're using one, is likely to be the processor. And that matters under the GDPR because depending on whether you are a controller or a processor, you have different obligations. So the controllers generally shoulder the highest level of obligations under the GDPR. They essentially have to comply with all of it. Whereas processors actually have much more limited obligations under the GDPR, although these obviously are still important obligations.
Certainly. I guess taking a step further too, how could you be a controller and a processor at the same time?
So in respect of a specific piece of processing, you're one or the other, but you can be a controller for some purposes and a processor for other purposes.
And, what are data processing principles? So now that we kind of have an understanding of the key players and how they're classified, what are the data processing principles that we really focus on, like Article 5?
Yeah, so the data processing principles are, controller obligations, and they sit at really at the core of the GDPR. So they're a set of principles that are expressed kind of at a really high level in broad terms about outcomes that need to be achieved, rather than sort of step-by-step procedural requirements that need to be met. And because they're expressed in this really broad way, they're really relevant to all of your processing, and you need to be thinking about them all of the time. So at a high level, the principles are that personal data needs to be processed lawfully, fairly, and in a transparent manner. It needs to be collected for specific purposes, so not just for some vague reasons that you haven't identified. You should only collect the minimum amount of personal data necessary to carry out those purposes. You need to keep personal data up to date and accurate. Personal data can only be kept for as long as is necessary to fulfill the purposes. You need to process it in a manner that ensures appropriate security, and controllers need to both comply with these principles, but also demonstrate compliance. So they need to be accountable for complying with these principles. So you can see in the way that I've described those, how broad they are and how they really can sort of relate to your processing practices generally. But in addition to that, they need to be understood as kind of informing all of the other specific obligations under the GDPR. So, if you take privacy notices as an example, the privacy notice obligations are essentially that you need to include certain information in a privacy notice that you give to data subjects. But the transparency requirement or principle means that you actually need to be really specific about the way that you include that information. You can't use sort of vague language about what you may or may not do. You need to present it in a really clear way and use plain language so that data subjects feel like the information is being communicated in a really transparent way. So, for all of those reasons, these principles are really central to the regime, and kind of having a good grasp on what they are is really fundamental to having a good GDPR compliance posture.
Yeah, that was extremely helpful. Thank you. And I think it's interesting to note as well that, when you're planning for a new regulation that's coming out, sometimes you say, okay, let's look. Data minimization, we looked at it once. Okay, we're done. When in reality, these principles come up constantly, right? Your job basically isn't done when it comes to data protection and privacy. You mentioned kind of like retention length, right? Keeping for as long as is necessary. Well, that's a constant question that you should be asking, right? How long have we kept this? Are we still using it? What is the purpose? So they're very intertwined, and you really need to understand kind of the explanation for each of these, for each type of data, for each category, to really get a full sense of whether or not you're implementing the regulation in the proper manner for your company, or treating the data in a proper manner that has been, shared with you and that you're processing. So these sometimes seem like very easy principles, but they're certainly quite complex, especially when you really dig into maybe how much data you have, the different categories, the purpose for each type of data. It can be quite burdensome to actually go through this in a proper manner. So Matthias, how do you process personal data lawfully under GDPR? So now that we understand the principles, it needs to be processed in a lawful manner, and how can that be done?
Yeah, sure. So the GDPR is set up so that if you're a controller again, you need to identify what's called a lawful basis before you start processing personal data. And there are kind of 6 lawful bases that the GDPR sets out in Article 6. So you can process personal data on the basis of the individual's consent. You can process it where it's necessary for a contract that you have with the individual. You can process personal data to comply with the law if that's necessary. You can process personal data if it's necessary to protect someone's vital interests. Essentially, that's a really high bar there to protect someone's life. You can process personal data if it's necessary for you to perform a task in the public interest. That's generally sort of reserved for kind of public bodies. Or you can process personal data if it's necessary for your legitimate interests or for the legitimate interests of a third party, provided that the data subject's rights don't override those interests. So, I think the thing to recognize is that there's 6 lawful bases. And if you're processing personal data, you need to be able to pin your processing to one of those lawful bases. Otherwise, you can't do it.
And it can
And then,
be any one of the 6, correct?
yeah, that's right. I think it's a common misconception that you need an individual's consent to process personal data under the GDPR. And that's not true. You can rely on any one of those 6 lawful bases as long as obviously the facts support it. You just need to make sure that you determine that before you start processing. And you need to think really careful about picking the right lawful basis, because once you've selected a lawful basis, usually you can't then pivot to a different one if you change your mind.
Certainly. And I think you make a really great point with regard to consent. A lot of times companies or individuals default, right? And they just assume, okay, it seems like the best lawful basis is consent. We just get it from the individual. We're kind of covered. When in reality, it may not be the best lawful basis for processing that type of data. And so how do you determine if consent is the right answer or if it should be, legitimate interest or one of the other lawful basis?
Yeah, it's a really good point, Alison. So consent has a specific meaning in the GDPR. It needs to be freely given, specific, informed, unambiguous, and it can be withdrawn at any time. So, that's a really high bar. It means that you can't sort of bury requests for consent at the bottom of your privacy notice. You can't use pre-ticked boxes. You can't even bundle different requests together. If you're going to rely on consent, you need to be really thoughtful about how your consent is going to hit all of those marks if you're going to obtain valid consent and therefore be able to rely on it as a lawful basis. But I think actually from a practical perspective, the main reason why consent can be problematic as a lawful basis is if you need to do the processing either way and you ask an individual for their consent to do it, well, they can obviously say no, or they can withdraw their consent later on, and then you're without a lawful basis and you can't undertake the processing. So, I mean, as you say, I think the temptation is often to go for consent as a lawful basis because it's a concept that people are familiar with. But it's important to recognize that there are 6 lawful bases, and actually some of those other lawful bases might be more robust solutions, thinking about whether you can rely on your legitimate interests, or if you have a contract with an individual, whether your processing is necessary for that contract. Sometimes those lawful bases can provide sort of a more robust underpinning for your processing.
Yeah, certainly. A lot of times as a company, you could be opening yourself to even more risk, right? By choosing consent. Either you're not, providing consent in the proper manner, following the criteria that you mentioned, or someone could withdraw their consent at any time, right? So then you're kind of in a situation where you need to pivot. And again, it's difficult to pivot to a different lawful basis. So yeah, certainly taking the time to really determine which lawful basis you can, fall under makes a lot of sense. Could you also have, I guess, more than one lawful basis, right? So maybe it's a legitimate interest, but you want to get an employee's consent as well. What would the harm be there?
So you need to identify one, but I think it's helpful to think about, to break down your processing into different steps. So, it might be that, you're obtaining an employee's personal data to, to carry out sort of metrics and understanding about the sort of diversity within your team. But you might also be collecting the same information to sort of run events within your team, or you might be also, like I said before, paying those individuals, and each purpose is different, although the information itself is the same. So you need to identify one lawful basis for each purpose, but you can have multiple different purposes for the same personal data.
Yeah, very helpful. Speaking, I guess, of withdrawing consent, the rights that data subjects are given are, quite essential to GDPR. And so what are the main rights that are given to data subjects?
Yeah, so I mean, data subjects have several rights under the GDPR, and I guess the thing to think about is they're all designed to give individuals control over their personal data in different ways. So at a very high level, the rights are, to transparent information and communication, to be informed about processing that's being undertaken about them, to access personal data about them, to rectify data that's inaccurate, to restrict processing in certain circumstances, to receive personal data about them in a format that they can port to other suppliers, to have their personal data erased in certain circumstances, to object to their processing of their personal data in certain circumstances, and not to have their data processed by solely automated means if that's going to have a significant effect on them. So it's really quite an extensive suite of rights, and these generally fall on the controller in terms of responsibility of helping data subjects facilitate the exercise of those rights.
Definitely. And I know you kept mentioning in certain circumstances, which is so key because yes, rights to the data subject are extremely important, but it also, depends on the situation. You can't just, delete everything that they request, right? Companies have certain requirements for retention periods, for maybe it's you need to hold your electronic communications for a certain amount of years because you're a regulated entity. So there's a number of different factors that come into play here. Maybe it's employment, employee data, and you need to keep it for a certain amount of time after an employee is no longer with the company. So again, yes, it depends on the circumstances, but we do highlight very much with GDPR the main rights that are given to data subjects, because I think this is also one of the times that we had seen, especially in regulations pertaining to data protection and privacy, where data subjects were kind of seen at the forefront, and the rights that they were given was just emphasized so much more than we had seen. So I think you're starting to see that more and more in the more recent regulations that have been coming out. But that was certainly something unique to GDPR in the region. You don't see that as much in other jurisdictions. So I find that to be interesting.
Yeah, I think it's a good point. I think it goes back to a point that Alex made at the start. Is obviously the right to protection of personal data is very central to the purpose of the GDPR, but the GDPR also recognizes the kind of commercial context that processing data sits within, and it recognizes that it needs to strike a balance between those two things, and that's why these rights, for example, are not absolute. There are carve-outs that make them workable from a commercial perspective from the businesses that are processing this personal data as well.
Certainly. I know the company that I work at, sometimes you will see, a data access request, whether the employee still works here and they're just interested in seeing kind of feedback that they received end of year, right? That's not necessarily open to them at the time, or someone has been terminated for whatever reason, and they kind of want to look under the hood and see what was in their personnel file. And, it turns into a huge report that I produced to them, basically explaining GDPR. And yes, you have these rights, but at the same time, we also need to protect other individuals and other data subjects and their rights as well, right? And their personal information. So sometimes, you're redacting a lot of personal data about that individual that's requesting the access, but you have to redact it because it's actually personal information that pertains to a different individual, right? So maybe it's a different individual's personal opinions or information that, would tell something about that individual. So it's a bit more complex than sometimes just, okay, you have access to all of this information. So it gets a little bit more complicated. But okay, now that we have established some of the basics of GDPR, how does this regulation, Alex, affect US companies?
Let me try it with the unmuted now. That's a really good question, and it quite often gets lost in the mix, right? Because a lot of people hear GDPR, it's European Union, how does it affect me? And the simple fact is, if you're processing data for a citizen in Europe or you have a European entity, you're pretty much into GDPR. If you think about it a little, the largest cross-border transfer of information and commerce is between the EU and the United States. It's in excess of over $7 trillion, excuse me. It's a big number. So in effect, pretty much every company in the United States of any heft is subject to GDPR, either directly or indirectly, just because of the nature of their business. But there's also a couple of other more subtle impacts there that I think often get forgotten. GDPR really set the stage for pretty much every other privacy and cross-border transfer situation globally. Now, there's some subtle differences based on the way some countries, historically how they've handled some stuff. But if you look at all the US privacy laws, all the laws in the United States, and there's 20 some odd, there's about 20 states right now, and there's, depending on how you count, somewhere between 4 and 7 sectoral privacy laws, and then you also have a few other things that are creeping in there. The fundamental principles of all of those can be found in GDPR. We've really done a good job as a global community of looking at how to align those, and you'll sometimes hear the term harmonization, where we've made these things look more alike than they are different. So a lot of times what you do for one actually makes you better at the other. So there's some good impact here that can't always be lost. The other thing is, if you look at the principles in GDPR that Matthias just went through very, very well, great description, those are good business principles, right? Like, one thing as a practitioner, I like to tell clients, you don't get in trouble for information you never collected. If you don't collect the information, you don't have to worry about protecting it, right? And one of the things GDPR does is it makes you think about why you're collecting information, how you're processing, how long you need it, right? It really causes you to start looking at your data strategy and your data processes, which is very beneficial. Then there's also some other more subtle pieces in here. So GDPR, on one hand, is not very prescriptive, right? So you go through GDPR, it's not like you have a checklist about do this, do that, do this, do that, right? It's really talking about principles. Instead of what you see in other places that are very prescriptive, you just go down the list. In support of that, the European Union has very publicly stated that you need to follow the intent of GDPR, not the letter of the law. There's actually some cases where some companies, one in particular that shall remain nameless, actually said to the European Union in their defense, hey, we did exactly what you said. And the courts came back and gave them one of the 10 largest fines because they followed the letter of the law, not the principles. And one of the reasons I bring this up is because artificial intelligence, and I know we'll get into that a little more as we cruise through, but AI is driven by data. Making a situation where we are rewarded or incented, or we think about collecting everything we can, but we don't necessarily think about how that can get us into trouble. By looking at things like GDPR, that causes you to find legal basis, that causes you to think about the rights of the consumer, that causes you to think about retention and protection requirements, it starts putting a check and balance against that AI-driven incentive to collect everything you can, even though you may have no clue how you'll ever need it, right? And there's a cost with that. It costs money to collect data. It costs money to store data. It costs money to encrypt data. It costs money to destroy data. Even though it's bits, it costs time and money, and it can get you in trouble, right? So I think there's a lot of ways that even if you're not directly subject to GDPR, being aware of the underlying principles that we just mapped out really benefits any organization, especially in the US, because the US privacy laws are so harmonized with GDPR. There's deltas, but you know what? I'd rather have an 80% solution that I can apply across the board and then focus on the other 10 to 20% that are particular to states and situations. So I think there's a tremendous amount of benefit.
Yeah, those are all excellent points. And I think an additional one that, makes GDPR more unique as well is this idea of privacy by design, right? So it's where, privacy by design really prioritizes data protection, privacy, integrity in the initial stages, but also throughout the development of a life cycle of technology design. So it's not really a new concept, but GDPR really makes privacy by design a legal requirement, right? So really to implement, technical and organizational measures when dealing with new products or processes or services that involve the processing of personal data. So, ultimately, privacy by design aims to encourage kind of the proactive embedding of privacy to safeguard privacy and data protection principles right from the start and then throughout the entire, life cycle. Which I think is something that has really been highlighted with GDPR that we had seen it, but it wasn't, again, like a key component and a legal requirement. So, to your point, it's important for companies to really closely analyze how they're processing their personal data and don't just collect it if you don't need it, right? Again, to your point, you're not going to get in trouble if you never collected it, but if you are collecting it, then why are you doing it? And putting kind of fundamental right of privacy at the forefront and accounting for it kind of every step of the way. So I think that's an additional element that makes GDPR unique and others are following in those footsteps.
Yep, absolutely agree.
So Mateus, what is a DPO? So you may need one, you may not need one, but high level, what are they and what are their responsibilities?
Yeah, so a data protection officer is an organizational role that the GDPR has created. And, the GDPR sets out in actually a fair bit of detail, what its responsibilities are, what its tasks should be, what qualifications they should have, and how they should be kind of treated within the organization. But so without going into all that detail, it's essentially a governance and compliance role. And so, the DPO essentially needs to be involved in all of the privacy related issues in your organization. They need to kind of report to the highest level of management within the business, and they need to be the point of contact with the regulators. So that's kind of what a DPO is at a high level. And you mentioned, you may or may not need one. That's right. So it's something that applies to both controllers and processes, but again, in certain circumstances. So you'll need one if you're a public authority. But if you're not a public authority, you'll need one if your core activities involve processing large amounts of data that's really sensitive. Or if you're engaging in systematic monitoring of data subjects on a large scale. And those are sort of, quite fluffy words, but what it essentially means is that if you're processing lots of data and you're doing kind of more high risk things with that data, then you should be thinking about, looking into that detail, whether you need a DPO. You're unlikely to need a DPO just because you're kind of processing, a handful of employees' personal data.
And Mateus, is there a downside in having a DPO if you don't necessarily fall under one of those categories?
So it's a good question. I don't think there's a downside, but you should be careful about what you call that person,
Mhm.
because the GDPR basically, as I said, kind of sets out requirements about how you need to treat this person. For example, there are kind of requirements around, how you can dismiss and kind of provide quite constructive feedback on, to these people. And so, I think it's good governance to have someone that sits, at the center of your kind of data compliance regime, but just be careful about, what you call them, how you label them, because if you label them DPO, then it's likely to bring all of the baggage that comes with the GDPR, the good and the bad.
Certainly, it's kind of like when people say, oh, well, I have a policy that says that we do all of these things. Well, if you don't actually do them, then it doesn't matter if you have the policy, right? So if you have the DPO, but they're not doing, all of the duties that they're supposed to be doing, then that is certainly an issue.
Yeah, exactly.
It also should be noted, I guess, in, different jurisdictions, the regulations are different. So, in Singapore, I know the DPO needs to be a local individual. So just being cognizant, if you have a global company or you're processing data globally, you may have more than one DPO at your company, just depending on jurisdiction or responsibilities. And they should certainly, obviously, be interacting and communicating as well.
Yeah. So Allison, thank you for stealing my thunder. I was going to say it happens to be one of those terms that can be very country or jurisdictionally specific. So you do need to, this is one of those areas where labels can be important. Again, putting my practitioner's hat on, what I always tell organizations, I tell them two things. First of all, if you have somebody designated as a DPO or not, somebody's going to be responsible. And Mr. CEO, if good news, bad news, unless you have specifically chartered somebody with that role, those duties and responsibilities, no matter what you call them, unless you've allocated to somebody else, it's you, right? So it's better to have somebody who spends a significant part of their day thinking about these issues and can properly inform you. They could do the training, they could, all the things that happen when you allocate responsibility. Unless you do that, you have to do it, right? So that's number one, whether you have one or not, whether you've named somebody or not, you have one. It's only a question of who. The second thing about the data processing role, and you got to play with titles, this person will quickly provide a counterbalance in the organization, right? They start making you think about, why did we collect that data? Do we need to collect that data? Do we need to encrypt it? Or can we use tokenization? They start to become a counterbalance, so you can still look at creating the value, but at the same time, you're mitigating your risk. So from a business perspective, more than just privacy, having this person provide that, it's kind of like the same reason you have a chief information security officer that focuses on information security or cybersecurity, whatever you want to call it. They balance that. And this would do it specifically around the privacy dimension. And guess what? Customers really like knowing they have somebody who's looking out for them. So there's a lot of benefits to having this role. Different titles. You might be careful about the title, but having somebody in that role, I am not aware, like Matthias said, I am not aware of any downside. The biggest thing you need to navigate is what's the title, because the moment you put that title on them, depending on the jurisdiction, there's legal and regulatory requirements.
Certainly. Yeah, I think the jurisdictional piece is key, which kind of brings us to our next point in terms of transferring data between the EU and other jurisdictions. So what is the impact of the GDPR in transferring data between the EU and the US, Alex?
Well, the short answer is none. The longer answer is it took us a while to get here. So again, the transfer of the financial transfer between the US and Europe is in excess of $7 trillion. And no matter what metric you use, that's a big number, right? It's important to a lot of people. There's also, in addition to the economic, there's a national defense dimension to it, right? Because we're all part of NATO. There's a lot of pieces to that. So what happened when we, without going through the history because it's very involved, um, when GDPR was put in place, and you have all these U.S. entities that are selling into, there's goods and services going back and forth. The the data that was in the EU, even though it's transferred to the United States, it still needs to be protected at that level or higher. And there's been a couple of things around that, but the most interesting of that is what's known as Schrems 2. There's Schrems 1 and there's Schrems 2. And if you look at the history, it's kind of interesting. There's one individual that has a history of bringing things to the EU court, and they're rather successful at it. That's why they now have a couple of things named after them, like the Schrems 2 decision. But what Schrems 2 did, and it's totally transparent to most people, because of the way intelligence activities were being performed predominantly by the United States, there wasn't sufficient protection of privacy information, like the individual's information. Like Allison was talking about how you have to redact. Okay? Simple. What do you redact? How do you redact it? Is there a redress mechanism? There's a few things like that, but they were all taken care of by an executive order several years ago by the Biden administration. If you want to look it up, it's the U.S. Signals Intelligence Act that was reinforced through an executive order. It actually overtook an old order, sometimes referred to as 12333, because it was Executive Order 12333. But the bottom line is, as long as you're doing, as a private company, you're doing all the things you need to do for GDPR and good security practices, it's transparent to you. And it's all been designed and negotiated that way. Same as we're seeing with other countries, not all of them, but we're seeing with a lot of others, and we are definitely seeing within the different jurisdictions in the United States. Sometimes in this space, well, in the security space, pretty much all the time, in regulatory space all the time, and starting to hear more in privacy, you'll hear things like reciprocity, which is a fancy way of saying, because I complied with this, those pieces translate over. So GDPR and the US have done that around the data transfers. And again, it's as long as you do what you're supposed to do, it's transparent to you.
Certainly. And I think it's important to note, you could really mention it any time in this presentation, but specifically here too, if you're not doing things properly, the fines for violating GDPR can be extremely high, right? So organizations that fail to comply with GDPR may be fined up to the greater amount of 4% of annual global revenue, or 20 million euros. So plus, data subjects also have the right to seek compensation for damages. So there's kind of, two tiers of penalties. The fines, can range from like more serious infractions, not having sufficient consent like we discussed, or, violating, privacy by design, to lesser infractions, not having your records in order, conducting, proper privacy impact assessments. So, we've seen a lot of very massive fines already for some of these, global organizations. And a lot of it is because maybe they're not getting the proper consent, but maybe they're transferring data improperly and they're not following these different frameworks that are in place.
Yeah, and to that point, and again, I'm the practitioner, so I see things a little differently and get involved in things a little differently. But sometimes what gets missed is you really kind of touched on it, because you're being fined on GDPR for this over here, doesn't mean it's only GDPR, right? Because some US states allow for a private right of action, which means in addition to the state and the European Union fining you, the individuals can sue you. It could be a class action lawsuit, could be a pile of stuff. but you also have fines and penalties from the AI Act. So let's say you were collecting data for artificial intelligence. There's device issues that come into play. An issue around your data can actually ripple through a lot of different places and end up with a handful of different regulatory and legal actions, right? So to your point, there's monetary incentive to get this right.
Yeah, and I think, another point to make there is, obviously there's monetary incentive and the fines are massive, but there are sort of other powers that these regulators have as well that can also be similarly problematic. So,
Yep.
the regulators can actually issue bans on processing if you're not doing it lawfully. And, that can be a business continuity issue if you need to put in place a workaround because, as we know, these technology processes are quite sophisticated and it's quite hard sometimes to change the way that you're processing personal data at short notice. So, it's definitely worth bearing in mind the fines because they are massive. But there are other powers as well that also give the GDPR its teeth.
Certainly. That's a very good point. Related on the US side, Alex, can you kind of go through the EU-US data privacy framework at a high level? I know it's quite complex.
Yeah, so we kind of touched on it a minute ago. This has now been put in place by executive order. Pretty much if you are complying with the GDPR and your state and local regulations, you're going to be fine. What it really does is it guarantees that because GDPR for the most part is more stringent. So it really created a situation where the US regulations and the transfer requirements were brought up to a level to meet or exceed that of GDPR. And the one where we got into the most amount of difficulty, that's a way of saying it, which is directly on point for the Schrems 2 decision, was the way intelligence activities were being performed. And it came down to how if something happens and then there's an information request through a number of different means, is it properly redacted? Does the individual have a right to, it's called a redress mechanism. So if a decision is made, do they have a right to contest the decision? It's actually pretty benign as far as what we as companies have to do. The bottom line is as long as you comply with GDPR and your local regulations, you're going to be fine. Now, there are some special circumstances that the average company doesn't have to deal with. Like if we're transferring certain types of intellectual property, economic or intelligence information, or munitions, not ammunition, but munitions, to a place in the European Union that requires some special licensing, right? Like export controls and the like. But again, you're already going to have those practices in place because if you have that kind of information, you play in that world, you're already subject to it. So the bottom line is be aware of it and understand as long as you comply with GDPR and whatever local regulations you have, you're going to be fine. And when I say local, that in the US, that really means based on sector or state.
Right. And we've talked a lot about, how companies should be approaching certain things, but Matthias, how should companies approach the contracting process in light of GDPR?
Yeah, so I think one of the most common contracting processes that the GDPR touches on is when you have a controller engaging a processor to provide it with certain services. So to use the payroll service provider example again, the controller engages the payroll service provider to provide it with services. I think there are a couple of key things to bear in mind if you're approaching that process from either perspective. If you're the controller, then start with due diligence, because due diligence is actually required under the GDPR by the controller before they engage their processor. But also from a practical perspective, most of the time the controller remains responsible for their processor's compliance. So, you want to make sure that you're engaging a processor who knows what they're doing and who has a good track record. And then in terms of putting in place the contract itself, so there are actually requirements around what you must do there. So you need to put in place a GDPR compliant processing contract. And that's all bound up in Article 28. So Article 28 says that when a controller engages a processor, they need to have a written contract, and it needs to include all these specific obligations which it lays out there. It's things like the processor can only act on the instructions of the controller. They need to put in place certain security measures. They need to assist the controller to facilitate data subject rights, that sort of thing. So that's the second part, is to make sure you put in place a GDPR compliant contract. And then again, if you're the controller, I would say, you need to think about continuously monitoring your processes' compliance with that contract, because again, that sort of goes to your broader obligations and responsibilities under the GDPR. So yeah, to summarize, I think when you're approaching the contracting process, I'd be thinking about due diligence at the outset, really thinking about, what are the requirements for this contract to make sure that I have a GDPR compliant processing contract, and then monitoring that compliance with that contract after the fact.
Certainly. And I think closely tied to everything that you just said is training, right? So you really can't train enough. Obviously, there's different levels of training. So if you're working at a company that processes information, that should be, global training for all employees, just on what personal data is, how it should be processed, how it should be handled. But then specific training too, right? If you're the ones that are dealing directly with the contracts, what exactly are we supposed to be getting in place? What information should we be asking? I think more specific training for those that have access to personal data or sensitive or special categories of data is key. So I know whenever a regulator comes in, they're going to be asking, what type of training did you do? What documentation do you have? What evidence do you have of this training? How frequent is the training? So there's a lot of, low-hanging fruit type things that you can teach all employees about, sharing on a need-to-know basis, keeping for as long as is necessary, keeping it, saved in an appropriate system with restricted access, whether it's, a hard copy, locking the drawers, the file cabinets, anonymizing data if possible, encrypting things, using strong, distinct passwords. So all these things should just be common knowledge to employees and to anyone that's processing data. But it's easier said than done, surely.
Yeah, no, I absolutely agree. I mean, things we see time and time again is companies have the policies and then they don't do the training. And you can have all the policies in the world, but if your employees don't know how to action those policies, then they're not worth the paper that they're written on, and you're still going to breach your GDPR obligations.
Certainly. And then, if there were to be an incident, right? People need to be trained on what happens when there is an incident, who needs to be notified, what type of record should be retained with regard to the incident, what type of remedial steps, who are we, reaching out to, everything. So it's kind of the entire life cycle of the processing, or if there were to be an incident, but the training kind of never stops, and it shouldn't, as these regulations are once they're implemented and they continue to evolve, so does your company, and so should the training that's related. So there's a lot involved. But Alex, I know you've continuously said like GDPR has set the stage for other data protection laws. So what are some of the other laws to be aware of?
Well, how much time do you have, right? Because there are approximately 140 different jurisdictions globally that have privacy laws. And if you think about that for a second, GDPR is only one of that 100 and approximately 140, but it covers 27 countries. So think about that for a second. Now, that's in contrast to the United States, who we could do a whole webinar on why. But in the US, we have 20 different states with privacy laws.
I think we do a
We have,
webinar on that, Alex.
sorry?
Said I think we do a webinar on that.
Oh, we probably do.
The
Yeah,
US.
yeah. Join us next month for that. So, good. I like the way you teed that up. Very good. So there's 20 states. There are, depending on how you count, somewhere between 4 and 7 sectoral privacy laws, right? And part of the counting thing is because there's specific laws, how privacy information will be handled for minors, which are actually in 3 categories. So there's a lot there. And then something that often gets forgotten in the United States is we actually have data protection laws, but not necessarily privacy laws. So, for example, California has one privacy law, one very famous privacy law that looks a lot like GDPR with different mechanics. But California has somewhere around 25 data protection laws, right? So this stuff gets very complicated very, very quickly.
I do want to leave some time, Alex, for DORA, which is the EU Digital Operational Resilience Act, which I know if you've dealt with GDPR, you're probably also in some respect dealing with DORA.
Yep.
I know that we are. So I do want to give some time to that. I know you've been working on that.
Well, let me hit that real quick. So related to that are really 2 things. There's this thing called NIS2, which is designed to, so GDPR is about privacy. NIS2 is about cyber hygiene. And the idea NIS2 is it's a requirement placed on all the countries to say you have to elevate cyber hygiene to a consistent level. Follows a very consistent format with the way GDPR was rolled out and all that. Some nuances, but you get the idea. DORA is specifically focused on the financial sector. DORA specifically talks about resilience. NIS is about resilience, but it doesn't say it as much. But DORA is specifically about resilience in the financial sector because of its importance. And that's basically the essence behind it. Now, in the US, we have a different structure for handling this, so we don't really have one specific act based on resilience, but we do have a number of very important initiatives around it. Most recently is the President's Council on Science and Technology, called PCAST, actually put out a report about raising the resiliency of the United States. There's some executive orders, standardization and all working around it. And elements have been folded into things like the CHIPS Act and the Inflation Act. Believe it or not, we got cybersecurity and resilience and privacy going into all these other areas like they should. So if you're in the financial services sector, pay attention to DORA. If you're doing any work in the European Union or with European Union citizens, pay attention to this too. If you're in the US, definitely keep an eye open for what's going on with resilience, because that's the next big wave.
Yeah, I agree completely. I think there's just a lot coming down the pike. And so it's never ending, but I do see a lot of overlaps, which I think is helpful, right? So if you were ahead of the game with GDPR, then you're going to be ahead of the game with some of these other regulations. And I see regulators asking a lot of the same questions over and over again, which I think is a good sign, right? You kind of want to see that consistency across the board. And if you are following it and being thorough with your due diligence and the way that you're implementing your policies, then you should really have nothing to worry about. But it does take a lot of time and effort to be done right. We have about a minute left, so I do want to leave it with both of you for just some last thoughts and any advice that you may have for the listeners. So Matthias, I will start with you.
Yeah, I think, one of the key challenges at the moment is, there's lots of novel processing opportunities and activities. And the challenge is to make sure you remember to think about doing that in a GDPR compliant way. There's lots of high value data out there, lots of sort of powerful analytics you can run on that data. We've got AI, becoming more and more prevalent, but fundamentally, if you're regulated by the GDPR, you need to make sure you do that lawfully. And we see lots of sort of examples of companies just sort of rushing out and wanting to make the most of that. For example, we've seen in the news social media companies wanting to run their LLMs on historic user data, and then receiving pushback from the regulators and having to pause those plans. And so I think that's because for a lack of planning and sort of understanding exactly what you're trying to achieve with that data, what data you're processing, what your obligations are, so that in advance of that you can kind of come to a well-considered position about why what you're about to do is lawful, and you can kind of defend that when it's interrogated. So that's what I'd be thinking about out of this.
Yeah, very good points. 10 seconds, Alex, go for it.
Real simple. A lot of the underlying principles in GDPR are found everywhere else in privacy. And there are a lot of the foundational elements that we see in good AI governance, right? It all comes down to the data, right? If you look at the biggest issues we see in dealing with AI, includes things like ethics, which has to do with the data. Bias has to do with the data, right? So a lot of what we're doing in this space comes down to those underlying principles and knowing what data you have, what you're collecting, and how you're using it.
Yes. Thank you both so much. Thank you, everyone that's listening. We really appreciate it, and we will see you soon.
Thank you, Allison.